Good afternoon, everyone, and welcome to today's Regulatory Transparency Project webinar titled Property and Personal Rights, a discussion of short-term rental regulations. We're so glad that you're able to join us today. My name is Libby Dickinson, and I am the Assistant Director with the Federalist Society's Regulatory Transparency Project. As a reminder, all opinions expressed are those of the speakers and not of the Federalist Society. We are honored to be joined today by a fantastic panel of legal experts. In order to get right to the discussion, I will leave individual introductions to our moderator. After the panel discussion, there will be a short period designated for audience questions. We ask that you submit them via Zoom's Q&A feature, not the chat, and that they are pertinent to the topic at hand. Our moderator today is Donald Cochin, Professor of Law and the Executive Director of the Law and Economics Center at the Antonin Scalia Law School with George Mason University. You can find out more about today's moderator and panelists at fedsoc.org. That is fedsoc.org. With that, I will hand things off to Professor Cochin to get us started. Professor, thank you so much for joining us today.
Thank you so much, Libby, and thank you to the Regulatory Transparency Project for hosting this webinar. As a matter of summary, a few things about short-term rentals before we get to our panel. Short-term rentals, popularized by Airbnb, Vrbo, and others, have been given modern platforms for the customary alternative to hotels, in-home stays. Yet their rapid growth has prompted a wave of local and state regulations at odds with the practice and potentially limiting property rights. Regulations and restrictions have been driven by lobbying from the hotel industry, concerns about housing affordability, neighborhood character, and other regulatory assertions. While some critics, including city officials and interest groups, support increased oversight, others, including advocates of limited government and individual rights, contend that these services represent an exercise of property rights, enhance competition to the benefits of consumers in terms of options, quality, and price, and expand consumer choice. Supporters also note that there's limited evidence of significant impact on the housing market. This panel will explore the constitutional, statutory, historical, and policy implications of short-term rental regulation. Are local governments properly protecting community interests, or are they infringing fundamental property rights? Do regulations actually inhibit competition? What legal frameworks govern this space, and what should they be? Our panelists will examine these and other questions at the intersection of private property, regulatory authority, and economic liberty. Starting our conversation will be Ron Klain, who's the Chief Legal Officer at Airbnb. Ron oversees Airbnb's global legal and ethics functions and community policy team. Ron serves as the 30th White House Chief of Staff from January 2021 to February 2023. Ron's career in public service began as a law clerk, Supreme Court Justice Byron White. He was Chief Counsel of the Senate Judiciary Committee, Staff Director of the Senate Democratic Leadership Committees, Associate Counsel for Judicial Selection under President Clinton, Chief of Staff to Vice President Al Gore, Chief of Staff and Counselor to the U.S. Attorney General, and Chief of Staff to Vice President Joe Biden. In the private sector, Ron has served as a partner and National Practice Group Chair at the law firm of Melvin and Myers, as well as General Counsel of another technology firm. Ron's a graduate of Georgetown University and Harvard Law School. I'll go ahead and give the other two bios so that we can just flow quickly through the conversations. So Paul Clement is a partner at Clement & Murphy, PLLC. He served as the 43rd Solicitor General of the United States from June 2005 until June 2008. Before his confirmation as Solicitor General, he served as Acting Solicitor General for nearly a year and as Principal Deputy Solicitor General for over 3 years. Paul has argued over 100 cases before the United States Supreme Court, since 2000, he has argued more Supreme Court cases than any other lawyer in or out of government. He's also argued many important cases in lower courts. Paul's practice focuses on appellate matters, constitutional litigation, other high-stakes appeals, along with strategic counseling. Following law school, Paul clerked for Judge Lawrence Silberman of the U.S. Court of Appeals for the D.C. Circuit and for Associate Justice Antonin Scalia of the U.S. Supreme Court. After his clerkships, he went on to serve as Chief Counsel of the U.S. Senate Subcommittee on the Constitution, Federalism, and Property Rights. He's a distinguished lecturer of law at Georgetown University Law Center, where he also serves as a senior fellow of the Law Center Supreme Court Institute, and he is the Justice Joseph Story Distinguished Practitioner in Residence at the Gray Center, the Seaboyne Gray Center for the Study of the Administrative State at Scalia Law School. He received his JD, magna cum laude, from Harvard Law School, his MPhil from Darwin College at Cambridge, and his BS summa cum laude from Georgetown University School of Foreign Service. And finally, we're going to hear from Tony Francois, who's a partner of Briscoe, Ivester, and Bazell. He's deeply experienced in water and real property law, land use and zoning, environmental regulation, natural resources development, agricultural law, and constitutional law. He's represented homeowners, builders, farmers and ranchers, trade associations, local governments and water districts in administrative, civil, and criminal proceedings before state and federal administrative agencies and state and federal trial and appellate courts nationwide, including the Supreme Court of the United States and the Supreme Courts of many other states. Among the notable cases he's litigated, he served as lead counsel for several years in the Sackett case that many of you are familiar with. And he is also was an attorney at the Pacific Legal Foundation from 2012 to 2021. Before that, he was a lobbyist for 10 years and an attorney at McQuaid, Bedford, and Van Zandt in San Francisco from 1999 to 2003. He received his JD with honors from the University of California Hastings College of Law in 1996 and his BS in mathematics with honors from the University of San Francisco. So we have an incredibly distinguished panel that is all working closely in the various areas associated with property law, constitutional law, with short-term rentals and other areas that are implicated by today's conversation. So with that, let's get to the heart of the matter and turn it over to Ron Klain to introduce the topic. Ron.
Thank you, Professor. Thanks for that generous introduction. I thank everyone for joining us for this interesting topic. Obviously, it's a great concern to us at Airbnb. As the professor mentioned, though Airbnb and Vrbo and Booking have popularized this form of accommodation recently, the people staying in people's homes is a form of accommodation that has ancient provenance. In fact, it's in the Bible, of course. As we know, when Joseph and Mary were seeking a place to stay in Bethlehem, there was no room at the inn. So you got accommodation with someone in their stable. So it wasn't a great in-home stay, but in-home stays date back all the way there. But in our history, this is a fundamental form of accommodation in American history. And not only would the framers, I think, be shocked to hear the local governments are trying to prevent people from renting out rooms in their house to guests, the framers availed themselves of this form of accommodation, and the framing itself owes a debt to this form of accommodation. Back in 1787, when our founders gathered in Philadelphia, they finally decided they were going to draft a new constitution as the remedy for the problems in the states at that time. They sent out a call to Gouverneur Morris to come to Philadelphia and be the draftsperson for this document. Gouverneur Morris came to Philadelphia and needed a place to stay. He didn't want to stay in a hotel because the hotels were infamous for people going through your papers for lack of privacy. So he sought out a widow, a woman named Mary Daly, who rented out rooms in her home to keep her home after her husband had died and her family and her children moved away. He went to Miss Daly and he rented a room for her in Philadelphia. When he got there, another member of the convention was also staying there, Elbridge Gerry. And one day, in the fall of 1787, they were at Miss Daly's house, enjoying their homestay, when Alexander Hamilton came for a visit, and the three of them in Miss Daly's drawing room drafted the preamble to our Constitution. It was drafted in a homestay. So the connection between our Constitution and this form of accommodation goes back to the very founding period. And throughout our history, homestays have been part of what's driven our history in our country. The abolition movement in the early part of the 19th century was spread by preachers going to lecture in the middle part of the country, and preachers from New England going to lecture in the middle part of the country, staying in people's homes and seeing guests and seeing people and spreading their ideas throughout the community. And more recently in the civil rights movement in the 1960s, Brown versus the Board of Education was developed because Thurgood Marshall and his biracial legal team, which could not stay in a hotel under local law, stayed in homes throughout the South and met with parents and got them together as litigants in Brown versus the Board, staying in Linda Brown's house and gathering the families in the community to join together to challenge segregated schools. So this is a tradition in America. And I want to talk about some of the personal rights issues. I'm going to defer the property issues to Paul and to Tony, but I'll hit the personal rights issues, which may have a little purchase with the Federalist Society, but I think are important considerations. First of all, there is a First Amendment issue here. Your right to have people come into your home, to freedom of association, freedom of speech, as I said, throughout American history, ideas and concepts have been transmitted through homestays and guests and hosts, exchanging ideas, and people in the community exchanging ideas with guests. So I think there is a First Amendment right here. It's not quite the Second Amendment, but the Third Amendment to our Constitution does prohibit the government from mandating that you host troops in your homes in times of peace. And I think there's a negative implication there that the founders understood that people would host people in their homes. But it would be up to you to decide who you host, except in a time of war. There are also big Fourth Amendment privacy considerations here. Some of these ordinances really trample the Fourth Amendment. In New Orleans, local inspectors, without a warrant or any probable cause, can, if you host guests, can enter your home and measure the size of your bed sheets to make sure they're adequate, and do other kinds of spot inspections. In New York, before they totally banned short-term rentals, we know that inspectors visited homes without warrant or probable cause to see if someone had a guest in there. And so this kind of conduct, this overregulation of people's homes, does trample Fourth Amendment considerations. And then I will say, from a progressive perspective, the idea of order, liberty under the 14th Amendment, I think, definitely is implicated here. And the line of cases that, again, I know may not be popular with this group, it goes back to Pierce versus Society of Sisters, Eisenstadt, Griswold. They recognize a certain protection of home life and decisions people make about their homes, I think, clearly extends to who you have in your home. And Moore versus East Cleveland, which struck down a local zoning ordinance because it said that's purported to suggest that in an area that was zoned for single-family homes, a elderly woman couldn't house her grandnephews in her home because they weren't a single family, suggests that your control over who stays in your house is a fundamental right that you should have control over, not the government. So I think all these personal rights are at stake here. They're very important, and these local ordinances just trample on it. And why? As the professor suggested in his introduction, part of this is just anti-competitive activity by the hotel industry. For example, there's an ordinance in Clark County, Nevada, Las Vegas, Nevada, that prevents anyone from operating a short-term rental in their home within a 3-mile circumference of a hotel. And it's hard to imagine what the public policy rationale for that is. That's a 2,500-foot radius between your short-term rental and a hotel, which is banned. In Las Vegas, you can have a strip club within 1,000 feet of a kindergarten, but not a short-term rental within 2,500 feet of a hotel. So it's hard to see what the public policy theory there is. And I think the effort to worry about this kind of overregulation of short-term rentals has drawn concern across the entire spectrum of the legal community. We recently had a case in the Michigan Supreme Court about this that drew amicus briefs from both the NAACP and the Goldwater Institute, because we recognize that keeping people out of people's homes raises personal rights, raises property rights. So I think this is an issue that a broad spectrum of people can take interest in. With that, I'll step aside and turn the floor over to Paul.
Great, thanks, Ron. Paul.
Well, thank you both. And I'll just, take the baton from Ron on this. When we first talked about this issue, Ron gave me sort of a pitch that was similar to what he just articulated very ably. And when I first heard it, my first reaction was to be excited about the Third Amendment. I've done a lot of Second Amendment work, and the third seemed like a natural follow-on. But on a slightly more serious note, I think Ron makes excellent points about all of the various constitutional provisions that sort of suggest in some kind of inferential way that there is something fundamental about the right to make decisions about how to use your home, who to let into your house, who to exclude from your house. But as a good textualist, my sort of first reaction was also, well, there's a provision of the Constitution that speaks directly to property rights, several, but the one that speaks most directly to it, of course, is the Takings Clause. And so kind of my point of entry into thinking about some of these issues was to think, what does the Takings Clause and takings jurisprudence have to say about short-term rentals and efforts by state and mostly local governments to do everything from banning short-term rentals to regulating them in ways that, as Ron well articulated, simply don't make any common sense, but might just pass rational basis, or maybe not in some cases, but just might just pass rational basis if there's no heightened scrutiny involved whatsoever. But sort of my starting proposition was the text of the Constitution does speak rather directly to the right of the homeowner to use their home and the limits on the government from restricting those rights in the form of the Takings Clause. And my initial point of departure in thinking about the Takings Clause issues was really the Supreme Court's recent decision in the Cedar Point Nursery case, where Chief Justice Roberts wrote very eloquently about one of the core components of the Takings Clause and property rights, in particular being the homeowners or the property owner's right to exclude. And the Chief Justice, writing for the court, sort of both emphasized that right to exclude, said that distinguished the regulation at issue there from many of the restrictions that we would think of as being regulated under regulatory takings doctrine. And so the court, I think, in that very important and muscular decision, kind of revived the per se takings doctrine and really got me interested in whether we could extend the right to exclude to also include a right to include. And certainly weren't drawing by any stretch on a clean slate with regard to making that argument. In fact, Professor Tom Merrill, in an article that the majority cited favorably in the Cedar Point decision, specifically talked about the right to include and the right to exclude as being just two sides of the same coin or a corollary right. And of course, these restrictions, particularly most dramatically, the restrictions that say that short-term rentals are just categorically forbidden, those restrictions do cut to the heart, are essentially a frontal assault on the right to include people as one way to use your property, and a critical way to use your property, really a way to unlock the value of your property. And for some homeowners, it would really be the difference between being able to afford their property and not being able to afford their property. So that was my original point of departure. And I think that is still a very robust way of thinking about these restrictions and why the per se takings doctrine should be applicable to these restrictions. But as we got into the research about that issue, one of the things that we uncovered that I think really strengthened the argument, and I now think of as almost like approaching the takings issue from the other end of the stick, is the really robust history of the courts recognizing that the right to lease one's property is one of the most core components of the property right. And this goes back really to the framing with the idea that you have the right both to enjoy the property yourself or to alienate it to a third party entirely through a sale, or to lease the property to somebody else so they can enjoy the immediate use rights while you enjoy the continued ownership in the property. And that's not just some feature of the property, like some that the government could regulate in some normal way. It really is a key stick to the bundle of property rights in a way that maybe distinguishes it from some other aspects of property ownership. And then one of the other things that we came across in our research that really made a powerful impression on me is that if you go back to the framing of the country, and it's also true if you go back to the Reconstruction and the framing of the 14th Amendment, you find that the right to lease really was the right to lease on a relatively short-term basis. I think some of us that come at this issue fresh from the perspective of 2025, excuse me, might think, well, a lease is the right to lease your property for a month or more. And we're, maybe used to the idea that you could rent a house for a year at a time. But at the framing, week-long leaseholds were very common, perhaps the most common form of lease. And so there is this real sense that when you think about these issues, you have to understand that short-term rentals are really not fundamentally different from rentals, and the right to rent your property on a short-term basis is really not fundamentally different from your right to lease your property or rent your property at all. And I think most of us would understand pretty instinctively that a state that tried to say, or a local government that tried to say, you simply can't rent your house. It's fine if you have the wherewithal to live in your house, but if you wanted to buy two houses and rent one of them, or you wanted to go abroad for a year and rent your house for a year, you simply can't do it. I think that many people would recognize that as such a substantial imposition on your property rights that we would think about it as being subject to per se takings analysis. And then I think once you recognize this historical pedigree for the short-term rentals, it seems very hard to understand why there's a fundamental constitutional difference between a law that says you can't rent your house altogether and a law that says that you can't rent your house for less than 30 days at a time. They're both fundamental impositions on one of the most fundamental uh, sort of building blocks, fundamental sticks in the property right bundle. And then I think from there, another thing that's worth recognizing is that some people, when they think about this issue, says, well, your property rights, you have a lot of rights to use your property in various different ways, but there's something different about the rental market or the commercial market. And indeed, some people have argued in the context of either restrictions in like homeowners associations or in the context of state and local laws that you can ban short-term rentals simply by saying that houses in certain areas are going to be limited to residential use. But that's an argument that has failed almost everywhere that it's been made, because when you're renting your house for somebody else to use it for residential purposes, you're not engaging in sort of what you would think of as a non-residential use or ordinary commercial activity. And again, I think most of the homeowner associations that limit the use to residential use are fully consistent with the idea that you can rent that property for 30 days at a time. And once you recognize that at the time of the framing, shorter term rental associations were the most common, the argument really sort of breaks down that you can treat short term rentals as either commercial activity or fundamentally different from other restrictions on rental properties. And then the last thing I'll say before handing the baton over is, when you think about these restrictions, they sort of come in sort of two flavors, if you will. The most obvious are some of the ones that that Ron has already alluded to, where it is just crystal clear that this is coming from the hotel industry. And as Ron points out, some of these restrictions, like they don't even bother disguising what is going on in these restrictions. And that's, of course, one of the fundamental problems when something is not constitutionally protected. You occasionally have state and local laws that don't even disguise what's going on. So to say you can't have a short-term rental within 2,500 feet of a hotel, just, it says the quiet part out loud. It seems obviously problematic. But to the extent you see other justifications for these restrictions, they often take the form of saying, well, short-term rentals put a greater strain on resources. Maybe they put a greater strain on parking. Maybe they lead to greater noise concerns and the like. So that's why state and local governments try to justify this. And to me, that gets into one of the lines that's always struck me from the Supreme Court's takings jurisprudence. It was, I think, originally came from a case called Armstrong, but it's been repeated many times since, which is the basic thrust of the takings clause is that the government shouldn't be able to impose burdens on particular property owners that, in all fairness and justice, ought to be borne equally by everybody in the community. And that's where I think some of these efforts to justify restrictions and bans based on concerns about parking or noise or the like, it really shows why the takings clause needs to apply here, and why the argument for it is strong. Because it's all well and good to regulate every house on the block and say that you can't have noise of a certain type at a certain time of night, or you can only have 2 parking permits on the street per house. But when those are imposed on everybody on the block, so to speak, it essentially guarantees that they're going to be reasonable restrictions that everybody in the jurisdiction can live with. But when those burdens are imposed solely on homeowners that want to use their house for short-term rentals, that's when you get the kind of massive overregulation that we've seen from some of these jurisdictions. But with that, I'll turn the baton over to Tony.
Great, thanks. And I'll just say one thing before we turn it over to Tony, and that is, the law and economics literature tells us also a lot about the incumbent disruptor story, and there is a suspicion of the additional justifications as being a masking concept when really it is anti-competitive behavior. That oftentimes there will be a public interest stated for things that ultimately are for the private interest of the incumbent interest groups, and so that, in addition to the concern about to the extent those justifications might be legitimate, ensuring that the public is bearing the burden, I would encourage folks to look at some of that literature to see where oftentimes we should be suspicious of those justifications as well. But I think we're also going to see some of this, how this plays out on the ground, with some further perspective from Tony. So let's turn it over to Tony to take over the conversation.
Thank you, and thank you to the Federalist Society as well. So let's look at a case study of how conflicts over short-term rentals do arise in particular communities and how they get resolved currently, and then what a better body of case law would do to help resolve those conflicts in a more principled and uniform and orderly way. So I'll use as an illustration a recently adopted short-term rental ordinance for West Marin County to illustrate these themes. Marin County is the north end of the Golden Gate Bridge, so kind of like over my right shoulder there. And the eastern portion of it, which is served by Highway 101, is urbanized. It's the part that's up against San Francisco Bay. It's pretty densely populated. And it develops slowly over time. But it's a not quite no growth area, but it has developed very slowly. The western part of Marin County is rural agricultural with a small number of very small communities, and is basically a zero growth zoning environment. In the West Marin short-term rental ordinance, I represented a small local real estate agency that has specialized for many decades in brokering vacation rentals of single-family homes in a small town on the coast called Stinson Beach. The Marin coast is served by Highway 1. It's one of the most scenic stretches of highway in the world, I would say. And this is the Northern California version of it. One of the things that drives a lot of vacation and visitor traffic to West Marin is the Point Reyes National Seashore. And so that also is served by Highway 1 principally. And so you've got small towns along the Marin coast, which are fundamentally longstanding agricultural and local small business communities. And then that is overlaid by fairly steady traffic of tourists and visitors who are visiting the coast, whether as day trips or as part of vacations, and very heavy use of Point Reyes National Seashore. And so these two uses overlay each other. But it's critically important to also understand the history of how this short-term rental ordinance came about. And my argument there is that the recent short-term rental conflict is significantly downstream of the zero growth zoning environment of West Marin County. Over a very long period of years, Marin County, in partnership with the California Coastal Commission, have successfully stymied almost all housing development along the California coast in Marin County and points north and south of there. And this is, among many other adverse consequences, made the existing stock of housing along that stretch of coast more and more valuable all the time, and the cost of it as rental housing higher and higher. Many of the coastal communities along Highway 1 are multi-generational families. whose children and grandchildren cannot afford to live where their parents and grandparents settled when things weren't so crazy. You see a similar dynamic throughout coastal California. The state's passage of its environmental review statute in the early 1970s, coupled with a very anti-housing zoning culture, has had the long-term effect of basically coating entire cities and towns in amber, freezing them in time. And among other things, this has created enormous wealth among the baby boom generation that bought houses there in the 50s into the 60s. And that effect is simultaneously driving out, for cost of living reasons, some of that generation's children and almost all of their grandchildren, because they cannot afford to live there, since there's been effectively zero housing growth for decades in this part of California. So one way of solving this cost of housing barrier for younger generations who, have the audacity to just want to live where they grew up, is getting some rental income on properties that they otherwise could not afford to debt service on their regular income, sometimes including, houses that they've inherited from their parents. Short-term rental platforms have made this vacation rental and short-term rental income opportunity very widely available to homeowners all over Marin County and obviously everywhere, by significantly reducing the degree of difficulty in getting vacation rental guests. And I think that's an important part of why, even though housing costs and rental costs in this area have always been high, the advent of easily used platforms, not just for people looking for a place to stay, but for people who own a property that they're willing to make available on a short-term basis to get into that market. The brokerage function of these platforms is key to, the easy use of a lot of homes for short-term stays. Meanwhile, you have also a younger generation of residents who've managed to stay in the area as long-term renters, and they face high rents because there is a very low absolute supply of housing of any kind along the coast or inland. And again, I want to emphasize, this lack of housing growth is a successful policy outcome advanced for decades by both Marin County and the Coastal Commission, the California Coastal Commission. So, this is, for that policy portfolio, what success looks like is that people can't afford to live in the communities they grow up in. And so they need workarounds. They need some other way to stay in the area they grew up. And then, as both Ron and Paul have mentioned, alongside both of these interests, homeowners and long-term renters, you have the hotels and motels, which are very few on the ground in West Marin, but reasonably numerous on the San Francisco Bay side of the county, served by Highway 101. That part of Marin County is much closer to San Francisco and other amenities in the Bay Area. And as with housing, because of the zoning culture in Marin County, they aren't printing too many new hotel rooms in Marin County along 101. And so those incumbents have a very strong interest in their position. And short-term rental platforms have presented them with significant competition. Okay? So this is the environment under which, or in which, a relatively recently elected Marin County supervisor, whose district is the coast, decided that his policy priority was to get a handle on traffic on Highway 1 up and down the coast, which, is what he wants to sell those who live there and therefore vote for or against him as his constituent service, and to see the visitors as adverse to the local community and, in a certain sense, the political other here. And so before long, Marin County introduced a two-step process to regulate short-term rentals, which the supervisor argued were exacerbating traffic on Highway 1 by making it easier for vacationers to stay along the coast and then do day trips up and down the coast and visit Point Reyes and, make things hard for local residents to get to and from. So the first step was a moratorium that lasted a couple of years on any new short-term rentals. And then as that moratorium was set to expire, he introduced a proposed regulation that would cap both at a countywide level and in each specific community the number of short-term rentals permitted. And this cap would then decline over time. And so you could get a 2-year permit, and then as the cap declined over time, some of those permits simply wouldn't be reissued. And if there were more applicants for permits than permits available, there'd be a lottery system or a priority system that would allocate the permits. And significantly, the initial cap was proposed lower than the existing number of short-term rentals. So you've got a significant takings problem with that cap, which is that those who are currently using their homes for short-term rentals have a vested property right in the legal and then conforming use of the property. And to the extent that they are forced out, they've got clearly valid per se takings claims. Another significant feature of the proposed ordinance was the limitation on ownership of short-term rental properties to a single property among related persons and entities. And, there's this big, we can't have corporations coming in and buying up all the housing. Okay. So the Planning Commission hearing on this proposal went about as one would expect. So owners of short-term rental properties testified pretty heatedly and properly, and certainly this was the position that we took for our client, that without short-term rental income, they would almost certainly have to sell and move and have to leave the communities that they grew up in. You had local renters testifying that an alleged boom in short-term rental use of properties was pricing them out of the market, as those properties, in their experience and their testimony, had previously been available as long-term rentals and at lower prices. So you've got owners being priced out of the market if they can't rent. You've got renters arguing that they're priced out of the market if owners are allowed to do short-term rentals. And of course, the hospitality industry keeping their lips wisely sealed about the whole thing. There was no testimony about from hotels and motels during the Planning Commission hearing on this, and very little discussion of that during 2 extended hearings on this ordinance. So the outcome of the ordinance, was some modifications to the caps that satisfied some of the longer standing localities that had featured a lot of vacation rentals. The answer, though, to how that is arrived at is, I think, really the key thing. How are these conflicts resolved? The simple answer is that they're not resolved legally, meaning they're not resolved based on well understood and universally applied or uniformly applied legal principles. They're resolved politically. Who was able to marshal the most effective political influence on the Planning Commission and the Board of Supervisors to make the desired modifications to the ordinance, particularly in the caps? So obviously we're pleased that our client was happy with the outcome of our work in that process, but it's worth reflecting on whether the best way to deal with these kinds of conflicts is based on who has the best connections or who does the best job of organizing community activists to browbeat the planning commission officials in the desired direction, whether that's really the best way to handle new economic realities like short-term rental platforms. So I think an important part of the answer raised by Ron and Paul is why the courts should do more work in this area is that they can provide clear case law where predictable legal precedents will tell county boards of supervisors and their legal counsel what the basic answers are. Can you cap? Can you prevent people from even having short-term rentals? Can you ration them? Can you price control them in ways that diminish the use of this economic tool? The more uniform application of legal principles from case law, I would argue, should be preferable to very localized backroom dealing and influence peddling, however well one manages to do that. And certainly influence peddling that is covered by community activism, where you've got one side of the debate benefiting, as Professor Kochen, highlighted between my comments and Paul's, benefiting the silent interest that sits back, and doesn't really declare itself, and yet is really the economic interest that benefits from the regulation. So if courts do get involved in this area and set clear rules based on constitutional protection of property rights, wherever these local efforts arise, they'll be resolved in a more orderly way, and participants in them should then feel, especially mere homeowners who want to make some side income with vacation rentals, less like they're getting scapegoated and rolled by activists fronting for market competitors, and more like they were treated fairly and justly under a uniform set of principles. And I'll, with that, hand it back to Professor Kochen, and maybe there's some questions we can all answer.
Great. Thank you all for your introductory remarks. And with that, I just want to ask if any of the panelists have heard something during the conversation that they'd like to reply to, or something that triggered a thought that you'd like to add.
If I could just quickly, a couple things that both Paul and Tony raised, I want to address. First of all, Paul referred to Professor Merrill's superb work in this area. He's talked about this right to exclude and the right to include as the gatekeeper right. And I think that's very palpable. When Koch said that a man's home is his castle, what's the fundamental element of castledom? You decide who you raise and lower the drawbridge for. And as Professor Merrill called it, the gatekeeper right. And so that's why I think the right to include, the right to exclude are two sides of the same coin. Paul also talked about the fact that short-term rentals go back to go back to the founding era. Rent leases for a week, it was commonplace. In fact, the #1 founder himself, George Washington, between the time he was elected president, the time he took office, wasn't sure where the government would be long-term. So he rented a room from John Adams week to week from the house that Adams had taken in New York. And he paid the vice president-elect rent every week for the house he had taken in New York. So Washington himself did this. I've heard a lot about noise, traffic, things like that. I do think these things are largely pretextual. There's been a lot of studies, academic studies, independent studies done of calls to 311 and 911 in cities. What we find is that those calls about local disturbances arise no more often from short-term rentals than any other kind of property, and that short-term rentals account for less than 0.2% of the calls to 311 complaining about noise or disruptions in an area. So regulating short-term rentals as a way to regulate noise is just ridiculous. And in addition to being unconstitutional as a taking of property, it's just not empirically backed up. Same thing goes for this housing concern. We don't have enough houses in America. You're not going to create more houses by telling people they can't rent out part of their house to guests. We need to build more houses. And and houses where people live, so that, where people work and whatnot. So I think that's the other issue. We have seen a giant social experiment in how this works in New York. They passed Local Law 18 in October of 2022. That took effect October 2023, that banned all short-term rentals in New York, pretty much. What's happened? Have rents gone down in New York? No. Are apartments more available in New York? No. What's happened? Hotel prices have skyrocketed in New York. The average hotel room was up $200 a night in New York since Local Law 18 passed. And New York's basically pricing itself out of travel for most people. And we see the same thing place after place. It does not make, banning short-term rentals does not make more housing available for long-term rents, doesn't bring rents down, doesn't increase apartment availability. We have to build more housing to do that. We need to reform permitting laws to make it possible to build more housing. And so I'll just stop there.
Paul, did you have any comments you want to make?
I mean, I would just say that, in listening to Tony and describe sort of, the facts on the ground, I mean, you really do see that, the motivations for some of these restrictions are, some of them are economic, some of them are just pretextual. It's the people who have, the quasi, not monopoly, but they have the vested rights in hotel rooms in another part of the county, and because of limits on development, those are scarce, and those are a valuable resource. So there's a lot of different things that go into these regulations. And right now, in some respects, you can see almost the manifestation of what happens when regulators are thinking about this as if they're not constrained. They do things that really push the limits of bare rationality. Ron talked about that sort of Las Vegas regulation about not within 2,500 feet of a hotel. New Orleans has a 1 per block restriction on short-term rentals. And to the extent there's more than one person on the block who wants to rent, they have a lottery for who gets to do it. These things almost sound silly. I mean, in general, with something that is constitutionally protected, you don't expect your ability to do it is going to be decided by a coin flip or a lottery. Tony described this system where they put caps on the number of short-term rentals without regard to what the existing number of people that were allowed to do short-term rentals. And they have a cap that's below the number and, amounts to a takings. So I think that, and maybe this is similar to the point that Tony was making, but I think one of the important things we can accomplish by getting people to think about these regulations is not just being ordinary regulations, but subject to takings clause analysis, subject to more rigorous analysis is, I think if people have to take the property owner's rights seriously, then you're going to see there'll still be efforts to regulate. There's still going to be some of these disguised sort of efforts to get rid of the disruptive incumbent that the professor alluded to. But I think just having the framework in place and having people recognize that there actually are constitutional rights involved here, I think is going to be helpful in terms of shaping some of the regulations, even in the places where we don't necessarily have to go to court to get them declared a taking.
And we have several questions from the audience here. I think a spirit of some of them is captured in that last bit there, Paul. And I want to ask you, so these things like, exorbitant permit fees, unannounced inspections, application hurdles, tax reclassifications, STR only fees, housing caps or permit lotteries, those can kind of, I think you're saying, fit into perhaps in effect, a per se category of takings. And maybe just a quick comment on that. And then second is, what about when we get into the Penn Central area? I think at least we're having the conversation about property if we recognize the right. But can anyone on the panel kind of talk about, all right, what about short of these drastic, in effect, per se takings, how should the property rights analysis go in terms of regulating this space? And are there any externalities that indeed can be controlled through police power regulations?
So I'll take a first crack at both pieces of it, but I'd be very interested to hear other, Ron and Tony's perspective as well. Just on what I take to be sort of the initial question, which is one of the things we've seen here is, there's almost like the first generation regulation and the second generation regulation. And, the first instinct of some local governments is to just ban these things entirely or ban them going forward, maybe grandfather the people that sort of beat the regulators to the space. And I think those are definitely susceptible to per se takings analysis. Now, in some of the jurisdictions, we're into the second or third generation, and some of those I think are still quite susceptible to a per se takings analysis. I mean, for the second house on the block, there's no material difference between a law that says no short-term rentals and a law that says just one short-term rental per block. And so some of these really, even though they're second generation, they're not that sophisticated. But some of them, eventually, maybe it's the third generation regulations, get to the point where maybe it's harder to fit them into the per se box. But I do think this is an area, there is this tendency among people that work in the taking space to kind of think about takings a little bit the way you think about like First Amendment, where in the First Amendment context, generally it's like all about getting subject to heightened scrutiny. And if you don't get heightened scrutiny, you're going to lose. The government's going to win. And I think some people think about the taking space as either get in the per se box, or if you're in Penn Central, you're going to lose. And I think for some of the reasons that Ron alluded to, this is actually a context where even if we're in the Penn Central balancing, which, instinctively, I never like balancing, but even if you're in that Penn Central balancing, I think there's a real chance of getting some of these regulations struck down, because if you do anything other than rational basis, the purported justifications for this just don't wash. The noise concerns, parking concerns, they just don't wash if you actually do the analysis. We do have real world experiments in some of these cases, so it's not just a battle of an expert. We can really show that the 311 calls are not coming from the short-term rentals. And then, so I think this is an area where there may be, at the same time we argue for per se takings, this may be a context where you can use sort of call it Penn Central with teeth, but I think you can really make some progress even if you're in the Penn Central box.
Any thoughts on that from Ron or?
Yeah, I would just echo what Paul said. I think that obviously some of these restrictions are per se takings and should just be invalidated altogether, but others could be subjected to some kind of balancing test or heightened scrutiny, something beyond mere rational review, which passes everything. So, for example, in New Orleans, we have short-term rentals are banned in the French Quarter, and someone challenged this before Paul got involved, and there's a case that was heard in the Fifth Circuit recently on this, where the city of New Orleans lawyer said, well, it's because we're concerned about noise disturbance and community character in the French Quarter. One of the judges on the Fifth Circuit said, the French Quarter, bars are open 24 hours a day, 7 days a week in the French Quarter. And you're worried that someone staying in a house is going to cause noise? And so I think just any kind of scrutiny at all of that restriction, it falls. And, and I just think a lot of these things, as I said, are just kind of pure anti-competitive efforts by the hotel industry or hotel unions to ban people from using their homes this way. And when they aren't per se takings, they should be subject to some kind of rigorous analysis so we don't get the kind of horse trading that Tony was talking about. I don't think anyone's personal or property rights should be subject to the kind of wild bargaining that went on in Marin County to try to get a permit here and there. So I think some kind of judicial supervision of this is necessary. And while balancing tests also make me nervous, some kind of heightened scrutiny makes sense.
Well, and I think with that horse trading example, we get to the point of exactions, and is it really, focusing on that in a way in which the power that they're able to exert to force sort of a settlement from people to give up their rights? The more we recognize property rights, perhaps the less leverage there is. Tony, any thoughts on that or on the question before we turn to the next audience question?
Sure. Now, one of the aspects of the West Marin ordinance that I highlighted is the limitation on number of short-term rentals that could be owned. And that's a condition placed on acceptance of a short-term rental permit that I think is going to be difficult to get through a Nolan Dolan filter. You're giving up your right to do short-term rentals on other property in order to get the short-term rental permit for property number one. I think also building a little bit on Paul's observations about the historic practice of short-term leases in the founding era and more recently. One of the things this highlights is how different a property rights approach to these questions is from zoning. And a lot of these restrictions are adopted as zoning ordinances. And I think the more that the courts are confronted with zoning as a kind of an alien thing to property rights, the better. And in particular, one of the things about zoning and the zoning culture of most American communities is that it's very tightly bound to the mid 20th century business model. And so, you wouldn't have this kind of conflict in 1950 and 1960 because you didn't have technology that made it easy for, me and my home, in small town America to just make it available for vacation rentals or short-term rentals, business stays, things like that. And, that model very much favored established hotel and motel districts and things like that. Now, the zoning is years behind the social and business models that short-term rental platforms use, and actually it returns sort of practice, in communities back to something that looks a lot more like older areas, pre-zoning eras, and pre, large industrial eras, to something that's more peer-to-peer and entrepreneurial and less organized, if for lack of a better characterization. And looking at that practice, using short-term rental platforms from a property rights lens instead of through zoning is going to be important in a larger effort to free property rights from a lot of the zoning overlay that limits them.
Great. We had a great supply of questions from the audience, and I apologize that we probably won't get to much more than this last question here. And I want to, this is directed to you, Ron, from one of the audience members, do you know the lost transient and sales tax revenue in New York City or really anyone since the ban, any place where a ban took effect? And I might add to that, could you comment on the effects on local businesses that would otherwise get some of the tourist revenue from short-term rental parties if they were allowed, that gets lost as a result of bans and or high restrictions?
Yes, thank you. I don't have an exact number on New York because it's hard to know if guests just switched to hotels or stayed in New Jersey or where the revenue went, but it's in the hundreds of millions of dollars. And I think it's important to know that short-term rentals also play a vital role in civic infrastructure to host special events. We saw this recently in Chicago when Beyonce came to Chicago, and people stayed in short-term rentals, and otherwise there wouldn't have been enough accommodation for people. Cities that want to host, when the Republican National Convention was in Milwaukee in 2024, nominated President Trump, the city of Milwaukee could not have hosted a national political convention without short-term rentals to accommodate guests. People had to stay in Chicago and commute to Milwaukee. And these big events, the World Cup, Super Bowl, all these things need short-term rentals to make it possible for cities to host people. And also in the event of natural disasters, we've seen in Los Angeles, Airbnb is hosting thousands of people for free in Los Angeles who were displaced by the wildfires. We had the hurricanes in New Orleans where there's not that many short-term rentals. People had to live in the Superdome. And so having short-term rentals as backup civic housing is also a critical part of their contribution to the community. But we also know that by people staying in short-term rentals, the benefit of special events is spread throughout a community. So it's not all downtown, but people are staying out in the suburbs or in other neighborhoods, and they're patronizing restaurants there and shops and whatnot. And so people spend where they're near, as someone just said in the chat, and and so we distribute the spend throughout the city, and there's broader economic benefits from these special events.
Great. Well, I think we're close to time. I'd like to give each of our panelists 30 seconds to give their key takeaway on all of this. And you might include any predictions you have for where and when we might see some courts weighing in on this in a way that gives the kind of guidance that each of you have suggested. So why don't we start in reverse order and just take 30 seconds, Tony?
Very simply stated, when it comes to your property rights, law should supersede politics.
Paul.
I mean, hard to beat that for an aphorism, but I will say, these cases are headed towards a courtroom near you. There are efforts to bring lawsuits that are targeted at the jurisdictions that have sort of the worst of the worst. And, I do think this is an area where it's really ripe for the courts to come in. And as Ron said, get some level of scrutiny to this so that property rights are protected and that people have what is really just the most fundamental right to be able to use their property in a way that allows them to stay in their home, or in the case of some of these special events that Ron was alluding to, just being able to rent your house for one weekend. You can make your rent payments for 3 months and for a big event. And to stop people from doing that is something that we really need the courts to get involved in.
Ron?
Well, I'm not going to top either Tony or Paul. I like Tony's aphorism, and I like Paul's analysis. I do think that this is coming to a court near you soon, hopefully to a federal court, hopefully to an appellate federal court soon, and maybe even the Supreme Court in the not too distant future. This is just an important part of our society of property rights, and I think it needs some definitive law, so we're not in these kind of endless horse trading and political process all over the country. And so I appreciate everyone's time and attention today, and I hope people will keep this in mind going forward. I think this is a very important issue of property and personal rights. And thank you for the Federalist Society for convening this session.
Well, and I will add as a final note that many of the comments were asking about what are the implications beyond just STRs for this conversation. And I think if we had more time, we could spend another hour explaining why, recognizing property rights here will have impacts in the HOA debates or in other development debates. And so, as with everything, how you use your property has implications across the board for other types of uses. And so I think that we have learned some lessons here for those that are critically interested in STR issues directly, but that the courts will undoubtedly help us understand more about property rights more generally as well. With that, I do also thank the Federalist Society's Regulatory Transparency Project for hosting this panel. Thank you to all of the panelists for your great contributions to this. Thank you to the audience and for the great questions as well, which I'm sure will inform the debate and certainly makes it clear that we should have another one of these sometime soon to hit some of those issues. And with that, I'm going to turn it over to Libby to wrap us up.
Wonderful. Thank you so much, Professor Cochin, for moderating, and thank you again to everyone on our panel for joining us and for sharing your insights today. Thank you also to our audience for tuning in and for your excellent questions. For more content like this from the Regulatory Transparency Project here at the Federalist Society, discussing the regulatory state and the American way of life, please visit us at regproject.org. That is regproject.org. Thank you. you.